Hi folks, Mark Lewis here again to discuss the 341 meeting. What is a 341 meeting and what can you expect at such a meeting? After your case is filed, you'll receive a notice in the mail where to show up and what time and what date you have to be there. Always arrive at least 15 minutes early. Trustees tend to get a little upset when you're late, especially in Rochester. And you must bring your driver's license, social security card. If you don't have a social security card, an original W-2 or other for other documentation that would prove your social security number. In Rochester, they also like you to bring your bank statement showing the balances and any bank account on the day that you filed your case. Well, how do you know what day you filed your case? On your bankruptcy notice at the very top, it'll show you what date your case was filed. It's also a good idea to bring that information to Buffalo or to the other courts, Watkins Glen, Batavia, or Mayville that you may be going to, depending on where you reside. Like I said previously, your meeting will be in about a month after we file. You don't have to get all dressed up, but I wouldn't suggest that you come in shorts or raggedy jeans either. Your case will be called, usually they have, pursuant to a calendar that they have, they schedule so many appointments per hour. In Rochester, they run every hour. In Buffalo, they run every half hour. So in Rochester, it would be 9, 10, 11, 12. Buffalo would be 9:30, 10:30, 11:30. At the meeting, your case will be called. Your testimony is recorded by a tape recorder in the event that the court or a creditor wants to listen to that, to your testimony. It is available for them to listen to. The trustee will verify your identity by way of your driver's license and social security identification. Then he'll proceed to ask you a series of questions. I will be there with you to assist you in the process. But number one, you want to be truthful and straightforward with the trustee and answer all his questions as accurately as you can. In the event that you forgot to list some item on your bankruptcy petition, the meeting is the place where you must tell the trustee that you forgot to list a gun or a car or an air compressor. The trustee will ask you things such as, did you list all your creditors? Did you list all your items of personal property and real estate? Where do you reside? Where do you work? And if there's something in particular about your case that the trustee is interested in, he'll ask you about that as well. Typically, the meetings are fairly quick, unless you have a complicated case, and then it could be a little longer. But typically you're looking anywhere between 5, 10 minutes and 20 minutes at the most. The trustees have a number of cases to call that particular hour, and for the most part they're very good about keeping the cases moving and getting your case called. If the trustee requests that you provide some information to him at the meeting, you must get that information to him. If you don't, they could make a motion to the court, and then the judge will force you to give that information to the trustee. So it's better to get that information to the trustee as quickly as possible to avoid any kind of motion to the bankruptcy court which will force you to get that information, and in some cases you may be required to pay the trustee some money for him having to make that motion. So the bankruptcy meeting is called the 341 meeting under the bankruptcy code. It's typically the only meeting that you have to go to. After that meeting is completed, then you'll have to take your second course, which is a debtor education course, and we'll talk more about that in a different section on counseling certificates and debtor education certificates. So basically, the 341 meeting goes through your petition to make sure you listed all your assets and all your debts, and is a mechanism by which the trustee can ask you questions about your petition and to see that if there's any assets that you may be able to liquidate for your creditors. But as I stated previously, nowadays with the new federal exemptions and the wild card that's contained therein, you're probably not going to have to give up any assets, and you're going to know whether or not you're going to have to give up any assets, so you'll be prepared for that. But like I say, nowadays 99.9% of the time you probably won't have to give up anything, and you will get a discharge of your debts as long as you follow the system and cooperate with the trustee. Thank you very much, and have a nice day.